your ladyship will find, not through my good offices, but through Mr. Archer's good offices, a copy of Benyon,
Thank
a
you.
relevant passage from Benyon requested by Lady Justice Carr.
Thank you.
And if I may, I'll touch upon it when in the course of my submissions.
In due course, yes, of course. Thank you, Mr. Archer, in the meantime.
My lady, I was going to do my third point, which was plain meaning is a threshold issue. I'll take this very shortly, if I may, because this is a matter, I think, on which my learned friend and I have a difference of approach and principle. We submit that the court should look as a threshold issue whether or not the word debtor has a plain and unambiguous meaning. And if it does, there is no need for the court to have recourse to the other canons of construction, and in particular to whether or not there is a purpose of construction. And do so that on a very simple and straightforward basis, which is on the basis of the authorities that we have set out in our skeleton argument, starting at paragraph 17, which is the speech of Lord Diplock in Duport, Steel Limited and Sirs.
Do we need to go to the authority, or is this all that you're going to refer to?
All I'm going to refer to, because you don't have the authorities in your bundle, they were agreed by them kindly, and Practitioner says if he doesn't disagree with what the authority says, then you don't put it in the bundle.
Fair enough,
So
thank you.
that's where we got to.
Yes.
I don't understand he has any, he disagrees with the submission I make on the basis of these authorities, but he doesn't disagree with what the authorities say, as I understand matters. I'm just reading from the second half of that extract, where the meaning of the statutory words is plain and unambiguous. I read from 6 lines from the bottom. It's not for the judges to invent fancied ambiguities as an excuse for failing to give effect to its plain meaning, because they themselves consider that the consequence of doing so would be inexpedient or even unjust or immoral. In controversial matters, there is room for differences of opinion as to what is expedient, what is just, or what is morally justifiable, but under our Constitution, it's Parliament's opinion on these matters that is paramount. So it's only in cases, we say, in which the legislature has failed to convey its intention clearly or expressly or completely, that it's necessary for the court to construe through these sort of canons of construction, purpose of application, that the intention of Parliament was other than the plain meaning of the words. And the plain meaning rule is set out, we set out in paragraph 19. And why do I say that it's a threshold? It's on the basis of the, particularly on the basis of the extracts we've set out in paragraph 21 from Lord Reed in Pitter and Everett. He says, in determining the meaning of any word or phrase in a statute, the first question to ask is always what is the natural or ordinary meaning of that word or phrase in its context in the statute. It's only when that meaning leads to some result which cannot reasonably be supposed to be the intention of the legislature that it is proper to look for some other possible meaning of the word or phrase. And as Lord Bingham said in the Crown and Bentham, which we set out in paragraph 22, rules of statute construction have a valuable role when the meaning of a statute provision is doubtful, but none, whereas here the meaning is plain. Purposive construction cannot be relied on to create an offence which Parliament has not created. And if you were to substitute the word cause of action for offence in that last line, we find ourselves, in our respectful submission, in exactly that situation. As we understand matters, my learned friend relies on an authority which is in the bundle. It's the Attorney General's reference number 5, which you find behind tab 1 in the first authorities manual. He didn't take you to it, but this we understand to be the authority on which he relies in order to make good the point that purpose of construction can be applied regardless of my submission on the threshold. And this is a case in which the House of Lords adopted a purpose of construction, but it's equally clear in our submission that it was only done because in that case there was uncertainty about the meaning.
Did Bentham refer to this case?
I
I'm just
can't
thinking,
tell you, I
looking
don't
at
have Bentham.
your authorities are quite old,
Yes.
but Bentham, which you cite at para 22, does post-date this authority.
Yes.
Okay.
I'm afraid I don't have Bentham in the bundle, and I can't answer Lucia's question.
No, do I?
Perhaps, if it's important, Miss Moses could look on the internet.
I can answer.
Thank you very much. Sorry, so the facts are not important, but where's the principle to be derived from that Mr. Auden seeks to utilise?
And Your Ladyship, the helpfully we do have copies of Benyon in our bundle. It's quite a significant chunk of Benyon. The plain meaning rule is set out from page 475. 475.
So it's my fault, and I'm probably wrong. Caused the problem by interfering. Is there which bit is relied upon by in the Attorney General's reference case? Which bit do we use?
I'm sorry, forgive me. Forgive me.
Sorry, no.
I was answering. Forgive me. I have. Two passages. First is at 178B in the report.
So page 14 of the bundle.
Where Lord Bingham says, in seeking to overcome these problems, it is in my opinion helpful to begin by recognising the objects, which is I think plainly Parliament was seeking to achieve in Chapter 1 of this Act. So in those words, he is accepting that this is a case in which there is not a plain and unambiguous meaning. And on page 21 in your bundle, which is at page 185H in the report, Lord Steyn says, it is true, as Lord Bingham has pointed out, that the inclusion of section 17.2 of an offence under section 1.2 of the Act creates a linguistic difficulty, given the language in which section 17.1 is expressed. In my view, however, this point is decisively outweighed by a purposive interpretation of the text. So this is a case in which there were linguistic difficulties and there was uncertainty. He then goes on to say, no explanation for resorting to purposive interpretation of the statute is necessary. One can confidently assume that Parliament intends its legislation to be interpreted not in the way of a black letter lawyer, but in a meaningful and purposive way that affects the basic objections of the legislation. That's the passage relied on my learned friend. But the words immediately preceding them show that this was a case in which there was a linguistic difficulty. And so that's why a purposive construction was adopted. So when you read it in context, we respectfully submit that Lord Steyn is not advocating a purposive approach in all cases, but only in cases where the meaning of the text is unclear. And we say therefore that's consistent with the authorities that we've cited in our skeleton argument.
You're going to take us to Benyon.
Interpreted factors heading appears at the bottom of page 475 in Appeal Authorities Number 3, behind tab O. Bless you.
Thank you. 475, did you say?
475, and then it's the heading, and over the page is where the text begins. And under the heading comment, Benyon says this section sets out the plain meaning rule, namely, that where the legal meaning is plain, it must be followed. The rule is one consequence of the principle that the text of the enactment is the primary indication of the legislative intention, and therefore the legal meaning. And your ladyship will see that many of the extracts that have found their way into our skeleton argument are also cited by the author in this text. And it's really a matter of logic more than anything else. If your ladyship was to find that the meaning of debtor was plain and unambiguous, then there would be no need for you to engage in purposive construction. And that's the simple point we make. Perhaps I've elevated it too high as a canon, but that is the logical corollary of the plain meaning rule in our respectful submission, which is that if you do find that the meaning is plain and unambiguous, you don't need to go any further.
So this is a combination of your points 3 and 4 then, really, isn't it?
I'm coming to 4 in a second, because I'm then going to explain why I'm able to make the submission that it is plain.
I see.
I'm very grateful to Miss Moses, who tells me that the Attorney General reference case was not cited in the Crown and Benefit.
Thank you.
But I don't think it's contradicts, does it? So.
And so the real force of your attention will necessarily be on my 4th point, which is it plain and unambiguous? Is the meaning of debtor plain and unambiguous? And in our submission, it is when one looks at the word as defined by the statute and in context. Our starting point is the glossary at section 189. May I ask you to turn that up? It's in the second authorities bundle. And it's at page 365 is where the relevant definition appears. Can I remind you of the commentary offered by Professor Sir Roy Good in relation to this section? This is a section of the Act which contains definitions which are applied across the board within the Act, and they are closely defined and carefully defined. I'm going to come back in a moment to address you on the words unless the context otherwise requires, Lady Justice Carr's point earlier. But before I do that, may I take you to the top of page 365 and look again at the definition of debtor. Debtor means, except in relation to Green Deal plans, see instead section 189, the individual receiving credit under a consumer credit agreement. Just pausing there, that's the focus of Learned Friends' submissions in relation to the domestic construction of the meaning of the word debtor. The rest of that definition he relies upon, I understand, in order to raise his arguments under mar leasing. But we're going to focus, if I may, in my submissions on those few words. The individual receiving credit under a consumer credit agreement. And we submit that the statutory meaning is narrow because it is made up of a number of words that themselves have strict definitions. And our starting point is going to be looking at the word credit. Your ladyships will see that we've set out our submissions from paragraph 34 onwards in our skeleton argument on these points. The individual receiving credit under a consumer credit agreement is the definition. And the word that sits in the middle of that phrase is the word credit. Credit under an agreement. And our submission is that is that means that the credit has to go to a contractual debtor. And we develop our arguments in the following way. Section 9 of the Act provides the definition of credit. Section 9, I'm going to take you to now, is reproduced in the Good Encyclopedia. It's in your bundle with the Good Commentary at page 664 in Authorities Bundle 3. At the bottom of the page you see the words the statutory definition, and over the page are the words of section 9. The learned friend took you through them earlier. In this Act, credit includes a cash loan and any other form of financial accommodation. That's the wording in section 9.1. Professor Sir Roy Good has then, in his commentary, provided an explanation for the various elements that go to make up credit. And if I ask you to turn over to page 668, he provides, under the heading the ingredients of credit, with a summary of what credit constitutes for the purposes of section 9. And he has suggested that credit, in this context, involves, and if I may, I'll just read them out, the supply of a benefit, attracting a contractual duty of payment in money, the duty to pay being contractually deferred for a significant period of time after payment has been earned, such deferment being granted by way of financial accommodation. And as the footnote suggests, that definition in a previous form was approved by Sir Richard Scott, who was then the Vice-Chancellor, in the Court of Appeal in a case called Diamond and Lavelle. And rather than ask you to turn that up, you will see it reproduced at paragraph 36 in our skeleton argument. The way it was expressed then was debt is deferred and credit is extended whenever the contract provides for the debtor to pay or gives him the option to pay later than the time at which payment will otherwise be earned under the express or implied terms of the contract. But those words are reflected in the way that Professor Sir Roy Good has sought to explain how credit works in this particular context. And those words have been approved repeatedly in the Court of Appeal, as we say in the footnote to our skeleton argument. They're rather a daunting set of ingredients. They could be seen to be rather complicated. Professor Sir Roy, or the editors of Good, sought to explain in the commentary that follows some of their meanings. And may I take you to the bottom of the page under the heading Contractual Duty of Payment. And here the editors of Good seek to explain what's constituted, what attracting a contractual duty of payment means. That's one of the ingredients of credit. And what the commentary says is this: there are two aspects to this element of this ingredient. First, if the recipient of the benefit has no duty to pay for it, then he is not a debtor, and it cannot be said that the credit is being extended to him. Thus, an undertaking to make a gift is not an extension of credit, nor is the gift itself.
Sorry, could you give me that reference again?
Lady, yes, page 668.
Yes.
Under the heading Contractual Duty
Thank
of
you.
Payment, 24.10.
Thank you.
And it makes the point that your ladyship made earlier to my learned friend. Gift is clearly not credit, is it? I paraphrase. And the reason for it is that it is explained by Sir Roy Good there. if your ladyship turns to page 669, another of these ingredients is explained, that of contractual deferment of the payment obligation.
Sorry, I'm just slightly going back. So just really on the facts of this case, two aspects to this element. First, if the recipient of the benefit has no duty to pay for it, then he is not a debtor. That encompasses Mrs. Cooper.
Correct. She has no duty to pay.
There is no duty to pay.
For the credit. The credit card statement would be sent to Mr. Cooper.
We've got it in our bundle.
And it has his name on it.
Would a second card holder have a duty to pay?
No, depending upon the terms, but no, in my respectful submission. For this reason, that the additional card holder is somebody who is authorised to use a card, but on the account of the principal card holder.
And if there were terms and conditions making them jointly and severally liable, then they would be a debtor.
Then they would be a debtor.
Yeah.
But in terms of the credit as defined by Section 9, it is very strictly circumscribed. And it has these ingredients, as I said, approved by the Court of Appeal, which make it absolutely clear in my submission, which is where I'm going, that the only person who can receive credit, as defined by Section 9, is the contractual debtor. And although somebody else may receive a benefit, that is not credit. And unless, in the wording of the definition section, there is an individual receiving credit under an agreement, that person cannot be a debtor.
Is this the right time to bring in the privity of contract point then?
May I do that later?
Yeah.
Because I'm going to I'll take you to section
Yeah,
75 in a moment.
yes.
I've got very much in mind that the word extraordinary is what I've been focusing on over
Yes.
lunch. And I've got a short couple
okay.
of points to make on
Yeah,
that.
thank you.
But it's not just the contractual duty of payment ingredient which makes good my point. It is also the ingredient D, the duty to pay being contractually deferred element. May I take you to the top of page 670? And the commentary says this: it's a preliminary point. What the Consumer Credit Act 1974 deals with is not credit as such, which can in a general sense be extended without any contractual commitment to do so, but the provision of credit under an agreement. You'll recall those are the words in section 189. Hence the material fact is not when payment is actually made or when the goods or services to which it relates are actually supplied, but what is the contractual type of payment to supply. In other words, credit for the purpose of the Act involves the contractual deferment of debt. And in the next sentence you can see where why the word in usual nomenclature credit should not be confused with credit within the meaning of section 9. He says if a person takes credit without having been granted it, as where he is slow in paying his dentist bill or his solicitor's account, there is no extension of credit within the 1974 Act. And that's because credit is to be read as meaning including an element of contractual deferral of payment. If I can take you to the bottom of this passage, 5 lines from the bottom. Only where this deferment is not just an indulgence but contractual is there an agreement for credit. And again, to establish a contract, it is necessary to show that the supplier received some consideration for agreeing to the delay. That is the delay in payment. So, as we submit in our skeleton argument, paragraph 38, An individual, such as Mrs. Cooper, cannot have a contractual right to defer payment if they are not a party to the agreement from which it stems. Indeed, as the statutory definition in section 9 indicates, financial accommodation can only arise if there is a meeting of minds, i.e. agreement, accommodation, between the debtor and the creditor. So the only person who can receive credit under a consumer credit agreement is the contracting party to that credit agreement. And if you wanted confirmation for that submission, then I hope we provided in paragraph 39 of our skeleton, where we look at the statutory meaning of the word, the phrase consumer credit agreement. It's defined in section 8 of the Act as an agreement between an individual, the debtor, and any other person, the creditor, by which the creditor provides the debtor with credit of any amount. And that only works if the word debtor there is read in the way that we suggest, namely contractual debtor. And as we point out in paragraph 40, similarly, there's a theme emerging here. When one looks in section 189 in the glossary section, creditor is defined in clear terms as the person providing credit under a credit agreement. So the theme is that these various phrases, these various terms of art, all apply in this carefully constructed scheme in relation to debtors who are contractual debtors under agreements. And their contractual involvement is key. And so to go back to the facts of this case, the only person who could receive credit under this agreement was Mr. Cooper. And he is therefore the only person who satisfies the definition in section 1891 of an individual receiving credit under this consumer credit agreement. And Mrs. Cooper was not. She was not receiving credit under this credit agreement. She had no contractual obligations or rights under that agreement. She wasn't, of course, liable for the sums that were due under the agreement. So if she received a statement, she wouldn't have to pay it. She has no contractual right to defer any payments. And therefore, she is not a debtor. And the judge was right to find that she was not a debtor. And in our respectful submission, that is very clear from the scheme of the Act. It is clear when you put together the definitions provided in section 189 and you read the definition of debtor alongside the definitions of the various other terms that are included in that definition, notably credit and consumer credit agreement, as we have set out in our skeleton. And in the light of Professor Sir Roy Good's helpful analysis of the various ingredients of credit, I hope that the court can see how plainly and unambiguous the meaning in section 189, the meaning of section, the definition of debtor in section 189 is. And we do rely upon the fact that the Act has got this section and it provides these careful definitions. And I hope I've done justice to the care with which the scheme has been constructed by taking you through just a few of the elements in the last few moments. Before I leave section 189, may I make two further points? One, responding to Lady Justice Carr's comment earlier about the words "unless the context otherwise requires" right at the beginning of the section. The context is key. But my learned junior over lunch looked at the Act to see if there were any sections in which debtor, the word debtor, was given a slightly different meaning. And she found that section 140C, I'll take you to the 140C subsection 2 at page 354, was one of those sections. Page 354. This is headed Interpretation of Sections 140A and 140B. For what it's worth, 140A and 140B are sections in which the Act introduces what are called the unfair relationships provisions. And they are rules which allow for challenges to be made to the validity of an agreement on the basis of its fairness. But at subsection 2, you can see an example of where the Act does provide a different definition of debtor as the context so requires. So for these purposes, so there's references in this section and in sections 140A and 140B to the creditor or the debtor under a credit agreement include A, references to the person to whom his rights and duties under the agreement have passed by assignment or operation of law, and B, where two or more persons of the creditor or debtor references to any one or more of those persons. I don't necessarily rely on the content of those tweaks, but on the fact that they are there. And it is an example of where the Act has seen fit and necessary to depart from the standard definition of debtor, as the context requires.
Is this actually mentioned in section 75? Because there is an exception, sorry, 189, because there is an exception provided, isn't there?
That's the second. There's an exception to the Green Deal. This is the Green Deal.
Yes.
No, this is different to that.
Yes, so one of the things that I took Mr. Alden to task for was when he said we needn't pay any attention to the square brackets, and I said, well, we do, because that rather indicates that there's been a specific exception. So why shouldn't there be a specific exception in this case? And you're taking this to another one.
I am.
Yeah.
I hope it was we had listened and we thought this might assist.
Yes, thank you.
So just because it hasn't been specifically carved out in the square brackets in section 189 doesn't mean there aren't other specific provisions. Now, of course, in section 75 there is no such specific provision. And your ladyships may consider that adds grist to my mill, that the word debtor in section 75 should be treated in the same way as the word debtor in the rest of the Act, unless the context has, unless there's been a specific and express change to its meaning. That was very inelegantly expressed. I could put it far better, which is simply, there's no carve out in section 75. There are tweaks elsewhere. That supports my submission that section 75 should be read alongside the other references to debtor in the Act. And this might be a convenient moment just to turn up the helpful extract that Mr. Archer provided from Benyon, just to highlight some of the passages in here that may assist. Because we're on the meaning of the word debtor, and Lady Justice Carr suggested earlier that it might be useful to see how the law treats the different, whether a single term can be used differently within a single act. So 21.3, same words, same meaning, different words, different meaning is the heading. 21.3, there is a presumption that where the same words are used more than once in an act, they have the same meaning. That is expanded upon at the bottom of the page under the heading presumption that same words have the same meaning. There's a quote from Courtauld and Lee. But then at the bottom of the page, there's an extract from Lord Justice Leggett. And I can't find the footnote. In Crown and Good Law Project of the Electoral Commission, footnotes appear on the last page, from 2018, in which Lord Justice Leggett, who then was, said, it's generally reasonable to assume that language has been used consistently by the legislature, so that the same phrase, when used in different places in a statute, will bear the same meaning on each occasion. All the more so where the phrase has been expressly defined. And of course we have that definition in this case in section 189.
And the 74 Act was not a consolidating act, was it? I know it was a unifying.
It was a unifying act.
But it wasn't a consolidating.
No, I don't believe it was. No, I don't think it was.
That's where you may not be quite. That may be muddying the waters when it comes to these presumptions. But I don't think it applies here.
I was going to take you back to the helpful history of the Act in a moment. It explains that it was the parliamentary draftsman, parliamentary counsel was Francis Benyon. And Professor Sir Roy Good particularly points out this was the work of one draftsman. It was created by him. I can give you the reference to that in a moment. And the reason why that may be relevant is that there is a specific reference in this extract, which I've now lost, to the fact that one can page 4,
halfway down.
Weight of presumptions depends on context.
Sorry, the provisions were produced by one or more drafters working together to produce consistency.
Yes.
Yes?
Yes.
That touches on the last point you made.
And for what it's worth, the the reference in good is at page 584, paragraph 21.2, where Sir Roy Good recounts, and this may assist also Lady Justice Carr in her question from a minute ago. The original Act was, though not by any means unique, unusual for a modern statute. Unlike the great 19th century statutes, one sole draftsman, but are in some cases the work of many hands. The 74 Act was the work of one draftsman, Mr. Francis Benyon. It's a tribute to his skill, but his creation, widely praised for its lucidity and originality, managed to withstand the pressures of the following procedure. Now, forgive me, I haven't taken you to the various, there are passages in here which the learned friend I'm sure will wish to rely upon, but I may allow him to take you to those passages in his reply. Learned Junior, in response to Lady Justice Carr's question about whether this is a consolidating act, in a competing publication, Guest, the Encyclopedia of Consumer Credit Law, the editors say the Act repealed existing statute that regulates the supply of credit or the advertisement of credit, such as the Pawnbrokers Act, the Moneylenders Act, the Hire Purchase Act, and the Advertisements Hire Purchase Act, and equivalent Scottish and Northern Irish legislation. It replaced these enactments with a single enactment, far more uniform in its application, although with necessary concessions to differing forms of credit business. So it does repeal some acts. It repeals, as I said, the hodgepodge of legislation that had come before. Whether that is actually, but it does so in a unified way at the hand of a single draftsman. The last point I make is, I'm going to section 75 if I may now. May I respond to my lady's comment before lunch? Is section 75 extraordinary before I come to explain its workings in more detail? It's been so described by my learned friend. It creates a statutory liability, a joint and several statutory liability. It's not alone in creating statutory liabilities, obviously. So to that extent, it is not extraordinary. A similar scheme already existed, I understand, from what Sir Geoffrey Howe said in his speech to Parliament. If I can ask you to turn up Authorities Bundle 3, behind tab P, at page 538. You'll see at the top of the page there is a question from a Mr. Rost. And Sir Geoffrey Howe answers, that is not the provision to which I'm referring. This is on a slightly different ground. There are provisions to which I shall come later, dealing with the position of brokers in certain circumstances. I am dealing with what is known in the jargon as connected lender liability, the connection between the financier and the trader. The House will recollect that creditors' liability of this type already exists in the hire purchase field in certain circumstances. The bill will extend it to almost all other types of transaction where creditor and supplier are effectively engaged in a joint business transaction. So if by extraordinary and learned friend meant unique, it's not unique. It's a section which does extend, as I say, statutory liability to a third party. In that sense, it's not dissimilar from what happens under the package travel regulations.
The removal of privity of contract is also not unique if one looks, for example, at the third parties, the 1999 Act. I don't know what the title of the Act is now. Third parties' rights.
Rights against insurers, isn't it?
Yes, but that's different. It's the Act which enables people who are not party to a contract but who are intended to have a benefit under it to benefit from the contract even though they aren't parties to it. So it's not that extraordinary a notion of itself.
And that was an example I hadn't come up with, and I'm very grateful. But
It would help if I could remember the name of the Act. Anyway.
I'm sure that I've been told the name of the Act very quickly. But if my lady's question was, is it unique? The answer, I think, is no, because it predated the Act. Well, the liability of this type predated the Act, the old Hire Purchase Act. And in fact, the PTRs themselves are an example of a situation in which somebody is made liable for something, the organiser. They're made liable for the acts of others.
Contracts Rights of Third Parties Act 1999.
And the very general answer is it is, of course, not extraordinary to create statutory liability. But this particular liability is created by other statutes and has been. I don't know whether that answers your question or not.
Well, I asked you in those terms specifically about privity of contract because Mr. Audlin's starting point was to point out the congruence, the package tour regulations, and Section 75 in that privity of contract went out of the window rather. So I'm not saying that it was only aimed at the uniqueness or the extraordinariness of that, but you can't see any other issue that you need to deal with in respect of that.
Well, I'm now, if I may, going to turn to Section 75 itself.
Yes, which might answer the question. Yeah.
Well, I wanted to. I was consciously to ask the question. I hope I got the answer. Perhaps I haven't quite got as much of an answer as you would like. Forgive me. I may develop it.
No, I think you might develop it in terms of whether or not. I think you said that you were going to discuss whether or not there was any sort of contractual arrangement. Didn't you say that? No claim, no contractual claim for the purpose of Section 75 is your number 5, so you're probably going to deal with that.
I'll come to that now, if I may.
Yeah.
May I ask the court to turn up to Section 75, which is at page 334 in Authorities Bundle 2 behind the tab. Section 75(1) reads, if the debtor under a debtor-creditor-supplier agreement falling within Section 12B or C, and for our purposes that is, if a debtor under a consumer credit agreement has, in relation to a transaction financed by the agreement, any claim against the supplier in respect of a misrepresentation or breach of contract, he shall have a like claim against the creditor. So the elements are 1, a credit card agreement. And the debtor in our case, we submit, is Mr. Cooper. But if the debtor is to have a claim under Section 75, they must also have, in relation to a transaction financed by the agreement, a claim against the supplier for breach of contract. Now, this provision, we submit, implemented the policy objectives identified by the Crowther Committee to which you were taken earlier.
So what about misrepresentation?
Well, I'm not dealing with that because it's not a case in which there's an allegation of misrepresentation.
Okay, all right.
But I can.
No, don't worry.
I can. Yeah.
Anyway, right. That's a must have a contract.
So, just so that our notes are clear, so the debtor in the credit card agreement is Mr. Cooper,
Yes.
but he must also have, in relation to the transaction, a claim against the supplier.
Whoever the debtor is, let's start with, because there's a dispute as to who the debtor is.
Yeah, I'm just making sure that I've got your submission.
The debtor has to be involved in
Correctly
two
noted.
contracts.
Yes.
The first contract is with the credit card supplier.
Yeah.
But that debtor also has to have a contract with the supplier.
So it's not a claim against, a contract with.
That is what is envisaged by the Crowther Committee. What is envisaged by the Crowther Committee is a tripartite situation, which involving three entities, three people. Creditor, a debtor stroke purchaser, and a supplier.
You're going to come round to Mr. Good's, Professor Good's commentary on this in A and B and
I am.
central heating and everything else.
Yes. And when one looks back, and I won't take you back because you've been taken it twice already, I think, to the Crowther Committee's, those 2 pages of the Crowther Committee, you'll see that it's all premised upon the assumption that one person, the debtor stroke purchaser, has 2 contracts. A contract with the creditor and a contract with the supplier.
Can I just ask, this is an avenue, is there anywhere in the section of the compendium edited or produced by Professor Good which deals with the Crowther report on that point? You don't have to answer me straight away, but Miss Moses can perhaps can let me know.
I will not. Thank you. And that's the premise upon which this connected lender liability rests. Which is why when one looks back at Section 75, the like claim only arises if that central figure, the debtor purchaser, has a claim against the supplier in respect of a misrepresentation or a breach of contract. I'm focusing on the breach of contract. And a breach of contract only arises if you're a contracting party. You can only have a claim for breach of contract if you are one of the contracting parties to, in this case, it'll be the contract of supply. And in this case, of course, Mrs. Cooper was not a contracting party to the contract of supply, that is, on contract with the organiser.
So this is when I'm terribly sorry.
It's my fault. I just didn't hear those last 2 words.
Mrs. Cooper was not a contracting party to the holiday contract.
But what about the regulations?
Comes
then?
out now.
Right, okay.
Section 75 requires, and when one looks back at the Crowther Committee, one can see why, requires the claim to be a breach of contract claim. And it's our submission that the claim under the regulations is not a breach of contract claim. It's not a claim for breach of contract. It is a claim under the regulations, a statutory claim, by a non-contracting party. The liability arises not contractual, it is statutory.
I see the way you're putting your argument now. Yeah.
I'll take the words now to look at them, and then take it to one case called Kuoni, in which the distinction between a breach of contract and a claim under the regulations is apparent. So to the regulations. Regulation 15. Mr. Order was very careful to take you through the definitions earlier on of principal contractor and consumer.
Which page are you going to look at?
389 is where Regulation 15 finds itself.
Thank you.
And the heading is important. Liability of other party to the contract for proper performance of obligations under the contract. 15.1 reads, the other party to the contract is liable to the consumer for the proper performance of the obligations under the contract, irrespective of whether such obligations are to be performed by that other party or by other suppliers of services, but they shall not affect any remedy or right of action which that other party may have against those other suppliers of services. So this imposes a statutory liability upon the organiser of a holiday, package travel contract, in favour of a consumer. And you'll recall from Regulation 2 that for these purposes, which is Regulation 2.2 on page 376, consumer, and we are here elsewhere in these regulations, means, as the context requires, the principal contractor, first person, any person on whose behalf the principal contractor agrees to purchase the package, the other beneficiaries, or any person to whom the principal contractor or any of the other beneficiaries transfers the package. So for the purposes of this liability in Regulation 15, a consumer is either the principal contractor or is one of the other beneficiaries. It is undisputed that Mrs. Cooper was not the principal contractor. She is therefore one of the other beneficiaries. She does not have a claim for breach of contract as envisaged by Section 75, which has its genesis in the Crowther Report and that tripartite contractual scheme. She has a claim as another beneficiary, a statutory claim. Liability does not arise because she has a contract with the organiser, but because she can take advantage of the statutory cause of action provided by Regulation 15.1.
And to this, Mr. Auden says, no, look at the word any in section 75.1. And you say...
And I say it has to be the breach of it is what is envisaged by section 75.1 is a breach of the contract between the debtor/stroke purchaser and the supplier.
Because any has to be rid of the word any claim in respect of breach of contract.
Yes. And just taking a step back, Mrs. Cooper did not have a contract with the supplier. Her claim arises under Regulation 15. Regulation 15 is a statutory claim. It's a liability that arises under the statute, not under a contract. What's the touchstone for liability? I have to accept this, of course. It says so in the will. The touchstone is the other party to the contract is liable for the proper performance of the obligations under the contract. That's the contract with Mr. Cooper. So she is able to take advantage of improper performance of the obligations under the contract, or a failure properly to perform the obligations under the contract, but it is not a contractual claim, it is a statutory claim under these regulations. Am I alone in drawing that distinction?
I hope that's a rhetoric question.
No, I'm not. Sorry, that was rather hammy, wasn't it?
It was.
Please forgive me. A case called X and Quoney, which finds itself page 291 in your authorities bundle 1 behind tab K. It's the last authority. And I say immediately that this is not this isn't a case in which it decided that the point that I'm arguing. But one can infer from the approach in my submission support for the position that I've just outlined. This is a case about the package travel regulations. It was a rather different type of case. It was a case in which the claimant had been a contracting party and she had been badly attacked on holiday, and she brought a claim against the holiday company. And I should also say that a learned friend appeared for the defendant in that case. But in the decision, the judgment, which is a judgment of Lord Lloyd Jones, with the agreement of the other justices, I'd ask you to look at paragraph 8, in which he explains the proceedings. And he explains that at trial, Mrs. X's case was essentially that rape and assault amounted to the improper performance of a contractual obligation. Before the Supreme Court, although a claim for breach of the 1902 regulations was maintained, counsel for Mrs. X emphasised that the claim was essentially a claim for breach of contract. But the distinction is more clearly made in the penultimate paragraph in the report on page 311. Again in the speech of Lord Lloyd Jones, at paragraph 50, where he concludes as follows. Finally, I should mention that to arrive at these conclusions, it has not been necessary to address issues related to vicarious liability. In my view, vicarious liability is not relevant here. Quoney is liable both under the directive as implemented by the 1992 regulations and in breach of contract, because the services it undertook to provide were not provided with care and skill by an employee of the hotel, which was the supplier of services. So this isn't a case which decides the distinction between the two. It's a case in which, in my respectful submission, the distinction between the two is clear on the way that it was treated by in the Supreme Court.
So on the application to join, was there ever a draft particulars, amended particulars of claim?
There are particulars of claim. They're not clear as to they don't.
Because if your analysis is right, then it wasn't just a question of replacing the name of the defendant; it would have been repleading the cause of action. If you're right, and so I'm just interested to see how it was put.
Well, it would have been put by those who perhaps present a slightly different case to me.
Yes, no, I understand. That's why I said on the application to join, there was a draft amended particulars of claim
and the particulars of claim
and an amended claim form, I imagine.
They're in the bundle. Page 192.
That's right, so this is the original one, but the application, the 19.5 application. Oh no, this says amended. It says amended. But the amendments actually were only to deal with quantum, so we don't have a draft re-amended version that accompanied the 19.5 application.
No, we don't. What we do have, however, a witness statement from Mr. Sconomini.
Right.
In which this is tab 3 in the court, page 9.
I think you mean supplemental bundle, do you?
I'm sorry. Yes, I do. Forgive me.
Yes.
In which, I'm not sure it takes matters much further, but he says, paragraph 25, under section 75, the creditor, in this case, he says, under section 75, the creditor, in this case Halifax, are jointly and severally liable with the supplier of the service, Freedom. The claimant who sought a contractual remedy against Freedom as a beneficiary of the holiday contract has a like claim against Halifax, who are rendered jointly and severally liable by virtue of the Consumer
And
Credit
what do
Act.
you say about that characterisation?
Well, he's correct to say that it's a claim as a beneficiary, and that gives a flavour of, it supports my submission that, in fact, the true nature of her claim is not as a contracting party bringing a contractual claim, but it is as somebody taking advantage as a beneficiary of this statutory liability under the regulations. But it does reflect the position taken by my learned friend that this is a contractual remedy. I respectfully disagree.
So the original claim against Thomas Cook claimed for Mrs. Cooper on the basis that she was a beneficiary only, not that she was a contracting party.
Which I say is grist to my mill that it is a statutory liability it's relied on rather than a contractual.
It may be. Have we got the original claim against Thomas Cooper?
It's behind tab 12 in your core bundle.
Yeah, okay. I've got the amended particulars against Freedom Travel Group. So I'm terribly sorry. I thought when my lady questioned the claim against Halifax that there'd been a fresh particulars of claim.
I don't understand that.
No, I'm told there wasn't in
One
support
would have
of the
one would
application. There
expect
was
one, wouldn't one?
an-
You'd
arguably,
expect draft amended pleadings to demonstrate the joiner application, but there wasn't one. in
there wasn't.
No, my fault then, I misunderstood. So in this case, we see the original claim And there is a claim on the basis of the of the organisation and supply to the claimant, and the package travel, package holidays and package tours regulations apply, so that the claim was under the regulations, yes?
Yes. But I seek to draw the distinction that I do for the purposes of Section 75 for the reasons that I do. And I pray and aid the distinction made in the last paragraph in particular in Crown in X and Quinn as there being two distinct and separate causes of action.
The paragraph 50 that you referred us to, yes. Okay.
Lady, I'm very grateful. I promised to deal with the additional card holder analogy in Professor Sir Roy Good's compendium. I'm mindful of the time. I think I can do no better than ask you to look at the skeleton argument we prepared, because I hope all the points there are addressed.
That's fine.
It's under the heading additional card holder analogy on page 52 in your core bundle.
Yes.
And the key point is the one that your ladyship made, which is that the analogy that Sir Roy Good draws there and the various musings, I think we've put it in our skeleton, are in the context of when the debtor, Mr. Cooper in this case, could be liable for something that somebody else has done with an additional card.
But just suppose I was wrong and Mr. Ordling was right, and that the A and the B are covering situations where there is no additional card holder, but it's just a domestic relationship of dependents. I mean, does it make any difference?
But what the commentary is doing is looking and seeing about as to when A is liable. So
you're saying we can't do what Mr. Ordling suggests and look backwards
no.
in the other direction?
No, because it's looking. His focus is on when the debtor can be made liable for something that somebody else has done, the additional card holder has done, which is it's an entirely different situation to this one.
Yeah.
And I hope we've set out paragraph 66 through to 70 why that analogy doesn't operate or doesn't assist you in this case. And so all of the logic that he prays in aid is...
No, I'm sorry, can I just...
Giving up.
Yeah. So 66 to 70, you deal with the second card holder.
Yes.
But Mr. Ordling, in discussion, when I raised the point, said, no, Professor Good isn't just talking about an additional card holder. So my question to you was, supposing Mr. Ordling's right, and it is not an additional card holder, it is somebody of domestic dependence, so the sister living in the same house, but not a card holder. And Mr. Ordling's argument was, well, in the same way as you look to see if A is liable for B's contract, the payment of B's agreement with the central heating firm, you can look backwards and say, if A was paying for the central heating, B was going to take the benefit of it. If anything happened, for example, if central heating exploded, I suppose, that B would then be able to sue the credit card holder if the central heating firm had gone out of business.
But the premise upon which all this rests is that only one person is liable under the credit card for the debt, and that is A. Which is why Sir Roy Good's analysis is
Can only go one way.
Can only go one way.
Right.
In what circumstances can A be made liable for what B has done? Whereas what your ladyship is grappling with is in what circumstances can B be the debtor? And that's an entirely different question.
But it's the question that Mr. Ordling is effectively asking us to undertake, because he's saying that debtor can cover Mrs. Cooper.
And
I hope it wasn't a completely stupid question.
No, not at all. But I'm, with great respect to him, he is asking you to draw the logic from various analyses, which are offered as musings, not as any concluded view,
Right. Okay.
on an entirely different topic. And he asks you to apply the same logic. But the underpinning of Sir Roy Good's analysis is that A, Mr. Cooper, is the cardholder, is the debtor under the credit card agreement. And what Sir Roy does not even envisage is that B is.
No, all right.
So I'm afraid it's an apple and pear situation in my submission. OFT and Lloyd's, may I deal with this briefly? Mr. Ordland took you to Lord Pope's speech in OFT and Lloyd's. He contends that because Section 75 does not exclude the possibility of the type of liability which he seeks to persuade you applies, then you should be open to the arguments that he makes. And more than that, you should be applying purposively the policy considerations that their lordships found particularly compelling in that case, involving the extension of territorial jurisdiction. But in that case, as Lady Justice Carr said, it is one thing to extend the territorial reach of a provision, and suggest that it's not inconsistent with silence that that territorial reach could be extended, not least because almost all provisions in our domestic legislation have no territorial reach, that they are silent on territory or jurisdiction. But it's quite another, in my respectful submission, to suggest that a provision should be interpreted to create a statutory cause of action, which is what Mr. Ordland suggests, and to say that because it is silent as to it, it doesn't stand in the way.
Particularly in the context of a carefully drafted and comprehensive piece of legislation.
Yes. I mean, it's trying to say that when you're creating a new cause of action, you have to be very clear as to when it applies. So, silence doesn't support him in my submission in that argument. So it's one thing to be silent about the jurisdiction, and you can then say, well, it didn't exclude it. But when you're actually saying, as he is, that this creates, you should read this provision to create an entirely new species of statutory liability for a new group of people, or extend statutory liability in favour of a large group of people, it has got to be done expressly. An analogy might be when you're creating an offence, you have to spell it out. When you're creating statutory liability, you have to spell it out. So silence doesn't assist him in my submission, which is, I think, the nub of his point. My lady, I've left myself virtually no time to deal with the Mar-leasing principle. I'm comforted to one degree that Mr. Ordland didn't deal with it in any great detail either. We have set out in our skeleton argument what we say about the Mar-leasing principle. And we've invited the court to read some helpful passages of, in a number of authorities, which trace through the principle. Forgive me, they may be authorities with which this court is very well aware. You needn't be taken to them. I don't want to waste your time now, particularly as I have very little time left in my allotted period, to go through them. May I give you some references
Yeah, can we just say, are you happy otherwise to rely on the
Yes.
skeleton?
I am.
Yes, we're all happy to rely on the skeleton, but any references that you want to make
May I?
specifically, yes.
And they are references to 4 authorities.
Yeah.
The first is a reference to the case of Marleasing itself. You'll find that behind tab F in bundle 1, the authorities, it starts at page 134, but the short judgment itself is page 151. And I was going to ask you to read paragraphs 6 through to 8 and 13. The second authority is a case called Pfeiffer.
Sorry, paragraphs.
6 to 8
Yeah.
and 13. Second authority is Pfeiffer. It's behind tab H. Again, a very helpful full authority report has been provided. The judgment starts at page 209. And we were going to ask you to read page 224, 102 to 119, but with particular emphasis on paragraphs 115 and 116.
What were the full range of the paragraphs again?
110 to 119.
With particular reference to?
115, 116, 117 in fact as well. In ICC and IDT, which is the next authority in your bundle, Revenue and Customs Commissioners and IDT, we're going to ask you to read page 251, paragraphs 79 through to 82, and then 85 to 89.
So my 251
Go
to
to 253, and you'll find that it's been transposed.
And finally, in Vodafone 2, a very short 2 paragraphs, page 281, paragraphs 37 and 38. And our headline points very simply were that the judge was right to conclude Marleasing was not even engaged because the Consumer Credit Act is not implementing legislation. It has to be construed in accordance with the directive.
Sorry, because it's
The Consumer Credit Act is not implementing legislation is the first point. And insofar as it is domestic legislation that could be effective under the Marleasing principle, although it doesn't implement the Package Travel Directive, it does not produce a result that is contrary to or in conflict with the directive. And that's because the aim of the directive, to repeat words I think I may have said before, is to provide a targeted scheme to protect holidaymakers, whereas the Consumer Credit Act regulates creditors, or regulates credit, consumer credit. And just because they have adopted different measures, that doesn't mean that they are in conflict or contrary to one another. in our submission, they are different ships on different courses with different cargoes, and they pass in the night.
Oh, yes, please. That's a few cliches too far, forgive me.
Forgive me.
Do you want to put that another way, just in simpler English?
Well, they do very different things. They're not aimed at the same consumer protection. They are different measures to deal with different policy objectives. And an important point, if I may, is that the Package Travel Directive contains a suite of particular measures to meet those particular objectives. They include informational requirements in Articles 3 and 4, statutory causes of action in Articles 5 and 7, and insurance requirements or requirements in case of insolvency in Article 7, as Her Ladyship Lady Justice Davies pointed out earlier. Those insurance provisions only cater for the cost of refund and repatriation. And so those who crafted this European legislation specifically turned their minds to what should happen if an operator becomes insolvent. And they decided that the appropriate measures would be to require insurance for the purposes of ensuring refunds, and that the cost of repatriation would be covered. They decided not to extend those provisions to personal injury claims that might arise, and that was a policy decision, in our submission clearly, made by those who drafted the directive, and that's why you don't find, to answer the question I think was asked at the outset by Lady Justice Davis, that's why you don't find anything in the regulations involving personal injury claims. And in those circumstances, I hope your ladyship sees where I'm going, it would seem extraordinary, given that the particular legislation and the directive has identified appropriate measures to meet the problem of insolvency. It would be extraordinary then, by reason of the application of the Marleasing principle or our domestic rules of construction, to accept the learned friend's submission and to read across into entirely different legislation a requirement to do just that. And if we're wrong about that, then the submission made in our scope an argument about the good reasons not to do this, not to read up. In the words of Lord Roger and Lord Nichols, you shouldn't read up if it goes against the grain or gives rise to important practical repercussions which the court is not equipped to. Those are all set out in our scope an argument.
89 and 90. Yes? Is that right?
Yes, exactly.
89 and 90, yes, thank you.
And the final point, if I may, conscious that I am now on my time, is that my learned friend's submissions at various stages suggest that this court should change the meaning of section 75 so as to confer that type of liability, or to allow others to make use of that statutory liability in circumstances in which they haven't got a claim against under the package travel regulations, and that would be essentially a progressive move by this court. He hasn't used the word progressive, but that is the flavour of many of his submissions. He speaks of the statute being always speaking and reflecting, therefore, modern society. Right at the back of your authorities bundle, you'll see a report from the FCA, which was relied upon below, Financial Conduct Authority. We refer to this in paragraphs 55 and 56 of our skeleton. And the FCA is under an obligation, in fact a statutory obligation, to review the 1974 Act and report to the Treasury whether the repeal of provisions in the Consumer Credit Act would adversely affect the appropriate degree of protection for consumers. And they produce a report to that end. And you have a couple of extracts from that report at the back end of your bundle. This report was presented to Parliament in March 2019. It's entitled Review of Retained Provisions of the Consumer Credit Act, Final Report. And on page 729 are a list at paragraph 5.34 of issues that were identified by consultees to this process with section 75. I needn't go through them all now, but there were concerns that were expressed about the way that section 75 was currently operating. And at 5.35, the report's authors note, although our view is that section 75 should be retained, to maintain an appropriate degree of consumer protection, we consider there would be merit in considering further the issues that have been identified with the provision. And over the page at 61, the report, again in relation to section 75, provides, we do not consider that we could use our general rule-making power under FSMA to make a rule that replicated the meaning and effect of section 75 and 75A. Our view, therefore, is the provision should be retained in legislation as their repeal will adversely affect the appropriate degree of consumer protection. However, as noted in chapter 5, and that's what I've just taken you to, we consider there would be merit in further considering the issues that are identified with those provisions to ensure that they provide an appropriate level of consumer protection without imposing undue or disproportionate burdens on firms, and to clarify or update the scope of section 75 protection. My simple submission, therefore, is that having conducted this review, it was not a case that the FCA, who are statutorily obliged to review the operation of section 75, were champing at the bit and suggesting that section 75 should be extended into these situations. On the contrary, it appears that the direction of travel is the other way. If I haven't done the ground 2.
Are you going to do what Mr. Ordling did and say that you rely upon submissions in the skeleton? I think we'd find that acceptable,
Yes.
wouldn't we?
I am. I'm very grateful.
Do you?
He and I had a discussion about the relevant gateway,
Yes.
and I think I don't know whether he's going to address that, and he is, and I'll leave it to him, because we had both premised our submissions on the assumption, at least on my part, that the gateway was the limitation gateway, sub-rule 4, not sub-rule
Yes.
3B, and
That makes sense to me, at least.
Well,
But it would help to have clarification.
in those circumstances, I would therefore only rely upon those submissions we put in because they address those points. Our respective submission was remitted. If we lose on the main principle, please just remit it back to the district judge. Not least because she didn't make any decision on the limitation.
But also because you failed to file any evidence on prejudice.
There is that point as well, that's right.
So you'd quite like a chance to do so if you need to.
I would.
Yes.
And make sure she has a proper listing this time if it does go back.
But I suppose the point is that the district judge didn't even address it. She said, look, no claim out. And so therefore, in our submission, perhaps the sensible thing to do, if we were to fail on them, ground 1 is for this court to decide to remit it. But I haven't done as well as Mr. Ordland in many ways. But and one of the ways I failed is I have 5 minutes over, for which I apologise to him and to you.
7 minutes.
7 minutes.
So, Mr. Ordling.
Eileen, on that last point, we did have a discussion. Obviously, the focus of today has not been on ground 2 for reasons which are entirely unsurprising. I look back at my skeleton argument, our skeleton argument, and it's correct to say that focuses on ground 4. I had a recollection that before, although the argument had gone differently in front of Deputy District Judge Campbell, I did pursue orally grounds, one ground under 3B, but may I have the opportunity to check, because I may simply invite your lordships to deal with it on the basis of ground 4, and we agreed between us that I would check my note from the last hearing, and if I could email your ladyships after this hearing.
Yes.
Can
we give you a timetable though, because we want to have everything, as it were, in a row?
I can do that overnight, my lady.
All right.
And I will confirm whether I just invite your ladyships to deal with it on the basis of the 4th gateway.
Yes.
Not the gateway 2 and 3.
Yes, that's
if
acceptable.
I may.
Yes.
And then it'll all be very straightforward, because the skeleton arguments deal with that one at length.
I don't want to overcomplicate at all. But 3B is not necessary. All I'm going to say is it's not necessarily entirely straightforward. We don't need to go there.
No.
Because you're going to look at your notes.
Exactly.
But I just say that without wanting to.
I will liaise with Mr. Riley Smith and then file an email with your ladyships if that's all right.
Yes, thank you.
In relation to, if I can take a brief reply in reverse order, in relation to leasing, there is no dispute as to the interpretation and the approach to that, which is why I didn't take your ladyships to the authorities, which we both cited in our skeleton arguments. You may find it of assistance to look at the Vodafone case first, that is the last in time, and paragraphs 37 and 38, which my learned friend cited and invited you to read, helpfully summarise the previous cases and pull together a neat summary of the principles. That's not to say I'm inviting your ladyship not to look at the others, but it may be helpful to look at it in reverse order.
Yes, thank you.
May I then deal with the additional argument, that's to say no claim in contract?
Yes.
We are, I think, at cross purposes here, or at least I submit that when Mr. Riley Smith submits that the appellant has to have a claim for breach of contract to get within section 75, I say that's reading too much into the rather wider scope of section 75. And as her ladyship, Lady Justice Carr pointed out, I say then any claim. But in fact, I say more than that, because if and perhaps I'll just invite your ladyships to have in front of you section 75. It's page 334, bundle 2. It's not just any claim against a supplier, it's any claim in respect of a breach of contract. It's decidedly not for and only for breach of contract by the principal contractor. That's not what it says. That's not what the express requirements are. And the package travel regulations give her precisely that. And when we look at the I invite your ladyships to have regard to the particulars of the claim, make clear that the claim was firmly and squarely brought in contract for breach of contract, albeit under the regulations. And if one looks at paragraph 6 on page 193 at the back end of the core bundle, it relies on the contractual terms and conditions from the defendant. It prays in aid implied terms under the Supply and Goods and Services Act. Now, pausing there, if it wasn't a claim in contract, there wouldn't be such a claim for an implied term under the Goods and Services Act, but there is. And then if one turns over the page, your ladyships will see under paragraph 7 that for the avoidance of doubt, this is the last sentence, breach of the terms at 6A, B and E above would constitute improper performance, that's the word used in the regulations rather than breach, of the holiday contract within the meaning of the package travel regulations. And I'm not going to take your ladyships back to the provisions which I took you to this morning, but my submission is simple. All she needs to have, providing she's a debtor, of course, is a claim, any claim, in respect of a breach of contract. She does not need to be the principal contractor. That is not what Section 75 says. And so I submit that that point is fails in my respectful submission. Insofar as going one or two other discrete points of reply, if I may. Insofar as my learned friend took you through the careful statutory regulatory regime, all of that is undisputed. It is a very carefully drafted, comprehensively drafted regulatory regime. But all I would point out, and again, is by reference to Section 75. Section 75 is not a regulatory provision. It is a statutory liability provision, and a wide one at that. And when he goes on to submit to your ladyships that it is in that very careful context, with careful definitions in Section 189, that it must consistently have only one meaning, I submit no, because the statute has expressly, you'll recall the words at the very preface to Section 189, envisaged that there may be circumstances in which words may have different meanings in different contexts. And I say, this is one such case. So when we come to the provisions of Benyon that were handed up over lunchtime in relation to same words, same meaning, and may I just complete the exercise by referring you back to two further passages that I would like to bring to your attention. The first of them on page 1 of that extract, please. Under comment beneath the first principle in the middle of the page, in the middle of that paragraph, like all linguistic canons of construction, this is no more than a starting point. These presumptions may be rebutted expressly or by implication. And then the same point is made over the page in the middle of the page, but the other passage I wish to draw your attention to was the top of page 3, and this relates to, I need to just cross-refer to footnote 13. That's only the, sorry, this must be from the previous page. So this is a decision in the case of Crown versus the Immigration Appeal Tribunal, and a citation from Mr. Justice Scott Baker, who said there is no absolute rule that one word cannot have two different meanings within the same section or subsection. True, it will only rarely occur, but the ultimate question is, what did Parliament intend? And what I say here is, here we have a situation where Parliament has expressly prefaced the definitions by saying some flexibility may be appropriate in some circumstances. There may be different meanings for different contexts. And I say, so it is. It is not hard to see why the meaning of debtor in the regulatory provisions of the Act may be quite different to the meaning of debtor in the liability imposition imposed by Section 75. And so when my learned friend takes you to the definitions of and the passages in good surrounding or commenting on those definitions, such as the contractual duty of payment, the contractual deferment, and so on and so forth, I say yes, there's no dispute between us. But the question is, are all those provisions the same and required to be imported when one construes debtor for the specific purposes of the statutory liability imposed by Section 75? And there we part company. My learned friend took you to Section 140C2 of the Act, which was at page 354 in Bundle 2. May I just invite your ladyships to look back at that, because it's my submission that in fact that isn't a different definition at all. When one looks at it, subsection 2, it says debtor under a credit agreement include, so it's not proscriptive, but it includes, and then the words that follow in little a and little b say in essence nothing more than what is in fact in the definition in section 189. So the first section, A, subsection, references to the person to whom his rights and duties under the agreement have passed by assignment or operation of law. As we've seen, that's in section 189. And then the second, B, where two or more persons are the creditor or the debtor, references to any one or more of those persons. Well, that adds nothing. Of course, if there are two signatories to a consumer credit agreement, they will both be. The definition will apply to them both, and vice versa if there are two lenders. So that actually shows us nothing insofar as Section 75 is concerned. It adds nothing to the definition of Section 189. Now, just have a moment. One last point, if I may, please. Could your ladyships turn to the last authority ex and quoni at the back of Bundle 1, authorities, and paragraph 29. And this is the judgment of Lord Lloyd Jones, bottom of 304 in the bundle, my lady. Regulation 15 of the 1992 regulation states that the other party to the contract is liable to the consumer for the proper performance of the obligations under the contract. In considering the scope of the obligations under a contract for a package holiday, it is necessary to have regard to the nature of the subject matter. A holiday is intended to be a pleasant and enjoyable experience. This is reflected in domestic law, citation of Jarvis and Swan Tours, also reflected in the approach required to be adopted in EU law under Article 5.2 of the Directive. It establishes a right for compensation for non-material damage resulting from the non-performance or improper performance of services constituting a package holiday. In Leitner, the Court of Justice emphasised that in connection with tourist holidays, compensation for non-material damage arising from loss of enjoyment of the holiday is of particular importance to consumers. I accept the submission of Mr. Weir on behalf of the appellant that the purpose of the agreement, namely to confer an enjoyable experience, encourages a broad, not a narrow interpretation of the holiday services contracted for. And the point essentially is that, yes, it's right to say that there is a statutory structure which sits over the contract, but it is not right to say then that Mrs. Cooper does not have a claim for breach of contract. She does. What the statute does away with privity of contract and puts her in the shoes of the principal contractor, so that any breach of contract to the principal contractor, she equally gets the benefit of. And so she has, I say, a claim in respect of any breach of that contract. Section 75 satisfied. Unless I can assist further, my ladyships, those are my submissions.
Thank you very much. We're going to reserve our judgments, obviously. We will send out a draft as soon as possible, but there's obviously a significant amount to take on board. Once we do send out our draft judgments, as you know, Mr. Ordling and Mr. Riley-Smith, you can correct our English but not our reasoning. It would be very helpful if in identifying any editing proposals you could combine the proposals in one document. We will anticipate your email by 4 p.m. tomorrow, Mr.
Yes.
Ordling, about the limitation point, the limitation argument. If there's any necessity to respond, Mr. Riley-Smith, of course, will afford you that opportunity, but please copy in Mr. Ordling. We would hope that there would be a clear indication of the order that we would invite you to draft. If there is going to be any suggestion, as Mr. Riley-Smith suggests, that if we are for you, Mr. Ordland, that we should remit the question of limitation, it may be necessary to extend your previous submissions on limitation. I don't know.
Yes, there are two ways in which your ladyships can remit, either to be determined as a preliminary issue,
Yes.
or to direct that the county court determine it, but at trial.
At trial, yes. All right.
But shall we cross that bridge if and when we come to it?
Yes. All right. Oh yes. So my lady reminds me, embargo on the draft judgment. There's now a list of appropriate recipients, as you all know, and again, as everyone is aware, there are measures taken against those who do not abide by the embargo, which is at least in part to deter others. So, all right.
Lady Justice Carr asked whether we might be able to provide any commentary in good on the Crowther Committee report.
In fact, it was me.
Sorry,
But I
forgive
won't
me.
take that amiss.
Yeah.
I was just looking terrified at that. No, I don't remember doing that.
As usual, I'm entirely reliant on Miss Moses behind me. She has found some references in good, and we can provide copies first of all to Mr. Ordland to check that he's content, and then of course we'll provide them.
Included in the email. Thank you very much. Thank you all very much. I should also thank, of course, Mr. Archer and Miss Moses, who've been operating behind you and contributing during the course of the session, and also, of course, your instructing solicitors. So thank you all very much indeed.